And if Bob Nukin said a few hours ago that the conference made his decade, then Bob, you made my decade a few hours ago when you said that my paper made, and I wrote it down, an extraordinarily interesting suggestion. And I hope that you all help me develop that suggestion. So as Bob indicated, my paper looks at the connection between changes in the substantive legal doctrines that we use to decide custody cases and changes in the dispute resolution procedures for those cases. And in doing that, I did engage, or tried to engage, both Bob's 1975 article that we've been talking so much about, and also his article with Louis Kornheiser, also incredibly influential on bargaining in the shadow of the law. So in that second article, Bob and his co-author explore the connections between substantive family law doctrines applied by courts and the negotiation and bargaining that occur outside the courtroom. And indeed, they argue, and I think quite correctly, that with the shift from fault to no-fault divorce, the main function of divorce law is not to impose order from above, but rather to provide a framework within which divorcing couples can themselves determine their post-divorce rights and responsibilities. Now, although the authors don't dwell on the forms of divorce bargaining, I think their analysis suggests that the changes in divorce doctrine will also affect the type and structure of the private ordering that parties are likely to engage in. And in particular, I think their perspective suggests that first, the elimination of fault as a prerequisite to divorce would start the process rolling, which began to undermine the utility of traditional adversary procedures for resolving divorce-related conflict, both in the courtroom and outside of it. So once fault requisites are removed, then neither courts nor private negotiators have to think about whether a spouse engaged in actionable behavior or who's responsible for the breakdown of the marriage. Those are backward-looking tasks for which the adversary system is arguably well suited. Instead, with the shift from fault to no fault, the primary role of the legal system begins to be take the much more forward-looking tasks of determining the financial and parenting consequences of marital dissolution. So rather than looking for towards the past, a no-fault system encourages both judicial and private decision makers to focus on the future and to consider what solutions are going to work for this reconstituted family. And for these more forward-looking tasks, I think both adjudicative and adversary procedures are at best unwarranted. So already with the shift from fault to no fault, I think you've started to suggest that the type of dispute resolution procedures ought to be different. And I think perhaps even more important than this shift are two related changes in child custody doctrine that take place over the next 2 decades after the rise of no fault. First, kind of the rise of what I think Bob called, and I would call, an unmediated best interest of the child standard. And then the subsequent and probably related, although I haven't really explored that, displacement of the prevailing sole custody regime with and here I made a change, I had said a joint custody paradigm, but I realize what I mean is not formal equal sharing of time, but this normative commitment to post-divorce co-parenting. So just to say a word about the best interest principle. So during the fault-based system, certainly we had a best interest principle, but it was operationalized through a series of fault and gender-based presumptions. So included not only the tender years presumption, which we've talked about, but the often competing presumption that a parent, certainly a parent who had engaged in adultery, and in many states, a parent who was deemed responsible for the breakdown of the marriage, was not the right person to obtain custody. And with the rejection of fault and the rise of formal gender equality concerns in the 70s and early 80s, these mediating presumptions largely went by the wayside, And the result, as I think Bob said in the law and contemporary problems piece, was this unmediated, highly individualized best interest standard that required a decision maker in each individual case to decide which custody arrangement, or at least which parent, would be best for this particular child. And there's a lot of aspects of that standard that are in real tension with the strengths of an adversary or an adjudicative regime. So, you know, and Bob in the article talks about a lot of these. It's a standard that is person-oriented rather than act-oriented. That's unlike most other legal standards in that rather than looking at a limited category of evidence and acts, it looks at everything. So everything about the parents, both of them, and their relationship with the child is potentially on the table. Second, you know, adjudication, adversary procedures designed primarily to determine past facts and act, not to predict future events. But of course, the best interest standard requires a prediction about what kind of arrangements are going to be good for children in the future. Now, as Bob points out, there are other places in the law where courts have to apply forward-looking standards, but almost always they're able to rely on presumptions or rules of thumb that make the outcome of this future-oriented prediction turn on a showing of ascertainable facts about the present or the past. And of course, the tender years presumption and this presumption against awarding custody to an adulterous parent were exactly these sort of mediating presumptions that were once applied in the custody context, and the approximation standard, which I'll come back to in a moment, would be the same sort of mediating presumption. But the rejection of those rules of thumb exacerbates, I think, the mismatch between a best interest, a backwards-looking dispute resolution regime, and a forward-looking best interest standard. And then a third problem with the best interest standard is that the accuracy of a decision maker's prediction depends in significant part on the future behavior of just those people who are before the court, and that future behavior is in turn dependent on the court's decision. So a good example that I think Bob Emery has written about is a judge may decide that a child's best interest would be served by having primary residential custody with mother and frequent and regular visitation with father. But a father might perceive this result of having lost the custody battle, lost the child, and so he may decline to visit and gradually withdraw from the child's life, so thus altering a central assumption on which the best interest prediction was based. Now, the very qualities, I think, that create the mismatch between this unmediated best interest standard and an adversary system evoke the strengths of mediation. So the person-oriented nature of the best interest standard, very consistent with mediation's emphasis on facilitating individualized solutions based on the participants' unique needs, right? The forward-looking nature, consistent with mediation's desire to shift attention away from past acts and grievances towards future-oriented predictions and solutions. To the extent that everything about the parents is on the table, well, certainly, as mediation proponents emphasize, parents are much better situated than either judges or lawyers to understand their children's needs, to consider a wide range of options. And the fact that mediation actively engages parents in creating a post-divorce parenting arrangements makes it much more likely that they will indeed shape their future behavior in a way designed to make the plan work. And I think the research very much bears this out. Even the vagueness and the indeterminacy of the best interest standard, I think, may be advantages in mediation, since those qualities help shift parties' attention away from reliance on legal norms in favor of their own unique situation, preferences, and values. So the aspects of the best interest standard that render it most problematic from an adjudicative perspective, I think, play to the strengths of mediation and other non-adversary processes. So This shift, I think, was accelerated by a second important change in substantive child custody doctrine, and that's the change from a sole custody to a post-divorce co-parenting regime, right? And under the sole custody paradigm, the job, as Andy Shepard has, I think, articulated beautifully, the job of a custody decision maker was to identify a single preferred custodian and assign that parent primary legal rights to the child. And both judicial decision makers and private negotiators, I think, operated within this sole custody framework. Prevailing psychological theory also supported the model. The Goldstein, Freud, and Solnit, who placed a very high importance on stability of the primary custodial relationship. In fact, such a high priority that they actually advocated granting the psychological parent the authority to preclude visitation by the other parent. And although no jurisdiction took Goldstein, Freud, and Solnit's views this far, I think their emphasis on a child's relationship with a single psychological parent provided an important justification for the sole custody model. It also cohered with then prevailing gender roles within the family. So the legal and social movement for gender equality that began in the 70s, I think, undermined not only the tender years, but also the sole psychological parent model. They faced with constitutional challenges to gender-based classifications, courts and legislatures abandoned reliance on tender years, first in favor of the unmediated best interest inquiry. At the same time, more fathers began to contest custody, and family courts were then faced with this burgeoning caseload of custody cases at the same time as they lost their lodestar mediating presumptions. And I think already uncomfortable with making custody decisions, judges increasingly began to do what Buffy and Bob wrote about. They began to say, we don't know anything about this. We better look to the mental health professionals. And I think the mental health professionals were very happy to jump into that void. At the same time, what was happening in the psychological theory was that it was shifting away from Goldstein, Freud, and Solnit's emphasis on a single psychological parent to the view that children were capable of forming close emotional attachments with more than one parent. And this shift coincided with growing research on the importance of fathers in a child's life. And that then fueled, I think, a really emerging consensus, which I think is now extremely well established among mental health professionals, that children generally do better if they are able to maintain ongoing relationships with both parents following divorce or parental separation, a result that the sole custody paradigm failed to facilitate. So a legal regime that was designed to effectuate the best interest of children was now under severe criticism as failing to serve children's needs. So doctrinally, I think the response to these developments was, the widespread endorsement of call it joint custody, call it post-divorce co-parenting, something that commentators have described as this small revolution in child custody law. I think the core premise is that while divorce may terminate the spousal bond, it does not dissolve the parenting partnership. In popular parlance, parents are forever. And if parents are forever, then this requires, I think, and has required a fundamental rethinking of the appropriate procedures for resolving divorce-related parenting disputes, right? If the idea is to supervise the ongoing reorganization of a family, I think somebody said it beautifully before, it's no longer about terminating the family relationships, it's about reorganizing it. Then what you need are not, clean break adjudicated procedures, but something that will help the spouses manage the transition from marital to parenting partners. And in addition, because this notion of co-parenting works best, maybe works at all, when parents are able to cooperate, then processes that diffuse rather than exacerbate conflict. and that focus on enhancing parents' ability to communicate are much more appropriate. And if marriage is now terminable at will, but parenthood is indissoluble, then divorcing parents need interventions that can help them renegotiate boundaries and disentangle their fractured spousal bond from their ongoing connection as parents. And I think family courts across the country have embraced these insights, and they have adopted, I think what Peter Salem has described as a continuum of non-adversary dispute resolution mechanisms designed to avoid adjudication of family cases. And they include not only mediation, which is a mandatory prerequisite to a digital hearing in many jurisdictions, but also divorce-related parenting education, increasingly parenting coordination, and other less adversary processes for resolving disputes. So those are kind of my thoughts on how changes in the substantive custody doctrine have fueled this shift from adversary to non-adversary dispute resolution processes. Can I just say I'm more tentative about looking in the other direction, but what I want to argue, and then I'll stop, is I think that that what we've seen, that the processes, the non-adversary processes, have in turn led to a delegalization of custody. That the parenting plan movement, I think, replaces custody judgments with planning. The role of law and lawyers is greatly reduced. Perhaps that's a benefit, but I'm not sure. And most tentatively, but I think most interestingly, courts and legislatures at the state level are increasingly rejecting the idea of custody altogether. So rather than turning towards a different standard, like the approximation rule or an emphasis on past caretaking, legislatures seem to be kind of saying, forget about custody altogether. Let's not use the word custody. Let's not use the word custodial parent. Let's not even use the word primary residential parent. Let's just talk about parents, time sharing, decision making. And I think that's important not only as a semantic matter, because Kate has really told us how important law's expressive function is, but I think that's important as a doctrinal matter as well.
Jana, thanks for a really terrific paper. Now, the first thing I have to tell you is that Jana was my family law professor.
Now you know how old I am.
No, I'm not saying how many. It was just 5 years
Oh,
ago.
yeah.
And I took Jana in my third year at law school at University of Maryland because I wanted a fun class, and I thought family law will be fun. I had no clue I would ever end up teaching it. It was an immensely fun class, and particularly because we talked about so many constitutional issues and things that I use in class when I teach all the time. So it's fun to be in this role now. The paper is fascinating, and I absolutely agree with everything you say in the first part of the paper about how the best interest standard has really led to the use of mediation, ADR, and other kinds of things. And I actually think that's the best thing about the best interest standard. Because what I tell students when we talk about the best interest standard in class is that parents, fear is a very powerful motivator. And the fear of what a court's going to do with this indeterminate standard means if parents have any sense, they'll figure this out on their own, and they will not let a court decide. And that's exactly what the parents should be doing, because this is a forward-looking thing. When parents are dividing a family and you're moving into two households, it's not looking back at what we've done in the past. It's how are we going to move forward. And so to the extent that that fear or that recognition that this is a very indeterminate standard gives parents an incentive to do other things, I think is actually a very positive thing for parents and for kids. And I think it builds on the work that Bob's done in terms of sort of the importance of mediation and what the role of, how the mediation process itself will greatly influence what the relationships are going forward. So I think that's all a very good thing. I think parents are the ones who are in the best position to make the best interest assessment. They know each other, they know their kids, they know where their kids are at that point and what they're likely to need in the future. And so all of the things that make it a bad standard for judges to use, I think actually make it the perfect standard for parents to use. And I'm going to say more about that when I talk about the second part of the paper. The other thing I think that's good about the use of alternative methods of dispute resolution and not relying on the adjudicative process relates to the fact that in addition to teaching family law, I also teach legal ethics. And one of the things we talk about in the legal ethics context, among many other things, family law is a great thing to talk about in legal ethics, is the access to justice piece. And the fact is that there isn't great access to justice for lower income and middle income families in the family law context, and yet that's the area of law where most people are going to need to engage the legal process, given the divorce rate and custody issues and so forth. And the fact is that once you hire a lawyer for the adversarial process, it becomes extremely expensive, both emotionally and financially. It prolongs the process, and it uses resources that really need to be put towards the family going forward. So to the extent that relying on other methods, including mediation and ADR and everything, collaborative lawyering and whatever, takes the financial cost down a bit, I think that also has it's a great thing going forward. It also, by doing, to the extent you take lawyers out of the mix, I think it helps to level the playing field. In your paper, in the Bargaining in the Shadow of the Law paper, it talks a lot about the imbalance and the risk-averse parent versus the gambler parent and what happens in terms of how that imbalance might exist. But I think that when you've got lawyers added to the mix, not all lawyers are created equal. And if you have a high-powered lawyer on one side and not on the other, then it creates an even greater disparity. And you bring the parents to the table with a mediator, you have a better chance of sort of getting back to first principles and leveling things and coming to a better resolution. So I think all of this is exactly why, the fact is that whatever flaws best interest has, it has had maybe the not intended benefit of helping to change the process a lot in ways that I think actually help families a great deal. I'm less sure I agree with you about the second part of the paper, which is where you've suggested that using these methods of dispute resolution have led to the, I think as you put it, the delegalization of custody as the legal rule. And what I would say is, maybe this is a semantics game, but I don't think that we've delegalized custody. I think we're going back to first principles a bit. If you have an intact family, and I'm talking about a married family because we're now dissolving it through divorce, where we know who the two legal parents are, and we're not trying to figure out who the legal parents or the natural parents or whatever are, but we know who the parents are, then the law considers both of those parents to have equal rights and responsibilities with respect to the child. And so, either parent could take the kid to the doctor or sign the permission slip for school or make decisions. It's only when the family splits up that then the state sees the need to come in and figure out what are we going to do about this. So, that's all for the family to deal with when it's intact, and both parents have essentially joint and several liability and responsibility for the kids. So what happens, I think in looking at how the best interest standard applies in the context you're talking about it here, is that what I see happening is that we're really going back to that presumption. And we're saying, look, both parents have these legal rights and responsibilities. We're not going to look at it in terms of a win-lose, who gets custody and who gets visitation. We're going to say, we're going to have to figure out how these parents now reallocate and take care of their responsibility for this child going forward, because they're still going to have those responsibilities even after divorce. And I think that also ties into the things we've talked about in terms of constitutional doctrine, because I think that part of what lies beneath our understanding of parental constitutional rights in terms of the liberty interest and the privacy interest is that we're assuming that parents are going to act in the best interest of the child, that it is doing that within the privacy of the home, that says we're going to trust what the parent's going to do unless something happens and the state needs to intervene. And I think that lies at the heart of cases like Troxel. I mean, we've talked a lot about Troxel today. And, what the court says is, look, there's a problem with this statute because there's no consideration of what the mom's saying. And there's all this discussion from Justice Stevens and others about like how it's really great and it's in the best interest of kids to have relationships with their grandparents. We're not talking about hypothetical kids and hypothetical grandparents. We're talking about what this mom knows about this relationship of these kids to these grandparents who may have been saying nasty things about her because their son had committed suicide, who maybe are putting pressure on the kids in some way that she sees as a parent, but that an outsider wouldn't necessarily see. And so I think honoring that assumption and presumption that parents are going to act in the best interest of kids is what underlies constitutional doctrine to some extent. And so I think what we're doing is not so much delegalizing custody as going back to an understanding of the legal rights and responsibilities of both parents and helping look at how we're going to reconfigure that post-divorce. The other thing I'd have to say is you talk about sort of the changing of terms like, parenting plan and time sharing, and I just can't help noting that Florida is a term that uses time sharing, and it seems like you're running a vacation condo. But I'm sure they weren't thinking about that. The other thing I think from that I drew on from part 2 of the paper is you're talking about how, and this is true, that the process is no longer so adversarial because you're now relying on alternative methods of dispute resolution and so forth. I don't think that makes it less legal just because it's not adversarial. That there's still a lot of law that's underlying it, and that parents are still bargaining in the shadow of the law as they're doing this. It's just a new assessment of sort of what the law means and what the standards are. A couple other things. You wondered and you discussed in the article about how the parenting plans and the approximation standard would really fit into this. And as far as I can tell, it still fits the same way because I still think that part of what we're focusing on is that when parents are making the decision, they're forward-looking. They're looking at how are we going to deal with this going forward. The ALI's parenting plan is forward-looking, is what's going to happen in the future, and it's looking at what are parents going to do in this parenting plan that they're then going to present to a court. The approximation standard looks backwards. It looks at past conduct. But it seems to me it's perfectly reasonable to say, look, parents, you all come up with the parenting plan, and you do it based on whatever you want, and you present it to the court, and the court's going to be expected to accept it unless it's completely ridiculous. But if you don't, the court's going to have to make a decision. And because the court can't look forward, it needs to look back, and it's going to look at past caretaking as a way to figure out what's the best thing to do. So that's part of what the parents are looking at in the shadow of the law, too. The other thing that I'd like to do is just to raise a question that goes beyond the scope of this symposium, because we've been talking about child custody. But the other issue that lurks out there for me is child support, okay? And part of what the parents are bargaining in the shadow of is what they're going to have to pay, okay? And one of the things about child support now is that it's much more determinative as a standard than child custody is. And it's a lot easier for parents to figure out. I do an exercise in my family law class. It's derived from one that Kate did years ago. And it's easy for students to Google and figure out what the child support would be. Parents can do the same thing. So I wonder how it affects the bargaining that parents can calculate that, but they can't quite figure out how the custody issue is going to resolve and how that influences what they're doing going forward. Okay.
Very
And
limited time.
and Kate's calling time. Yes.
Oh, yeah.
No. I seen my time since I've been over before, if anybody.
Maybe there won't be any questions, I don't know. I just wanted to reserve some time for you to get feedback from the rest of the group.
So let me say, if there's no, I really appreciate the comments, and I think the other turning the lens around is much less developed. But I really do think maybe it's the disaggregation of custody into day-by-day schedules and different types of legal decision-making that seem like a delegalization to me. And I'm not saying it's a bad thing, but it seems like at the essence of kind of legalization is coming up with concepts and categories, then really what's happened in, especially, in the mediation and other ADR processes, is those have been set aside in favor of trying to determine kind of day by day and decision by decision.
Yeah, can I just make one?
Yes, yes.
I think one factor in terms of the influence of the legal framework that's intangible and hard to measure is the extent to which parents' knowledge that if they can't work out a solution and plan for their children's future, a court will make that decision. And I think you can't, I mean, in your delegalization suggestion, I don't think you're paying attention to that disciplining effect of law.
But that kind of brings up the other, I think that one other piece of why the approximation standard has not been adopted explicitly by legislatures is because the main justifications for it speak to the adjudicative process. And legislators, I think, and the kind of the public at large is now thinking, oh, that's like, we don't want that process. For what we really want is we want a system where parties are steered out of the legislative process. And then I think it's easy for people to draw the conclusion that I think you, Kathy, you draw, very persuasively that actually the best interest standard is, a good thing for mediation, maybe better than a backwards looking, kind of past caretaking standard. So. Yes.
Quick comment, though, to, I think, confirm your last point, which I like very much. Imagine you're a mediator and you're giving a pitch to a couple that not high conflict yet. And they say, well, what's going to happen? You say, well, your goal is to create a parenting plan, how you're going to allocate child rearing responsibilities. And here are some of the things you ought to think about. Well, what ought we to be guided by? Well, you ought to be guided by your own knowledge of the child, your own needs, what you think makes the most sense for you. Well, what happens if we don't agree? Well, there will be a court that could decide it if you don't agree. Do you want to say to that couple where you're hoping they're going to work it out? And what the court will do is they're going to decide what's in the child's best interest. And of course, the problem is, different judges will decide that different ways. But what I want to underscore to you, I say this as the mediator, in terms of private ordering, you can almost do anything you want that you guys can agree to. Okay, that's message one. Message two is a different ending. Well, if you don't agree, what the court's going to do is impose an arrangement which approximates whatever the allocation of child rearing responsibility was in the past. And when I say that I saw a tension between the ideological aspirations of co-parenting, I don't want to call it about equality, but co-parenting on the one hand, and the need to have a determinate standard if the judge is going to imply it to resolve a dispute on the other, I think that's the dilemma. That's how, at least at the end of the day, I'm now understanding kind of part of what's going on here. And that's only part of it, but I found very helpful your
Thank you.
presentations in that regard.
I'll send it to you.
Well, Bob, I hope you're going to address whether best interest is good for mediation, because that was your segue.
Okay, sure. First, I got to see if I can get this PowerPoint to work. What do I press, Bruce?